Studio 11 in Auckland Park, Johannesburg, and we're ready to interact with you on issues that piqued your interest. It's just gone 8 o'clock. It's Topical starts right now. A very good evening to South African, those watching around the world. My name is Blaine Herman, and this is It's Topical. Our digital audience is with us tonight. Good to have them on the program as always. Today's top story. We woke up to the news of the passing of Ambassador Jessie Duarte, a long-time anti-apartheid activist who served as special assistant to former President Nelson Mandela, passing away on the eve of Nelson Mandela International Day, a day set aside for making a difference in your communities. Many say Ms. Duarte did just that. We'll have much more on her passing during the roundup, so stand by for that. On to the topic of the week: professional legal practitioners, ethics, code of conduct. In terms of what the general public expects from them, is the bar high enough, mind the pun? What does ethical behavior entail? Look, gone are the days when only journalists and people interested in a particular case are privy to court proceedings, or TV programs such as Law and Order or Ally McBeal shape your understanding about court processes. I know I'm showing my age mentioning those programs. No. More and more cases of national interest are being beamed straight into your living room, your office, and you're getting a first-hand look at the conduct of judges, of prosecutors, of defense lawyers, etc. The Senzo Meyiwa murder trial is a case in point, which leads us to our question of the week. How should legal practitioners conduct themselves in open court to inspire trust? The person you just saw there on your screen, Advocate Teffo, is in studio. We will talk to him in a short while. Follow me for context. Give us a call. 011-714-5958. We'd love to take your calls on the program. You can also tweet us at It's Topical SABC. We talk here about your understanding in terms of how these legal practitioners should be acting now that we are more and more seeing their cases on TV at It's Topical SABC. Now, time for your roundup. Of the day, let's take a look at the most topical story of the day. The late ANC Deputy Secretary General Jessie Duarte has been described as a pillar of strength for the ANC and a woman who fought for a just and non-sexist society. Now, President Cyril Ramaphosa delivered the eulogy during her special official funeral, Category 2, at the West Park Cemetery in Johannesburg earlier today. Ramaphosa described her as a faithful, dedicated, and fiercely loyal leader of the African National Congress and a champion for the equality of women. Duarte lost her battle with cancer at the age of 68. Now, with regards to the topic of the week, you know by now that this show gives you a voice as we reflect on the big stories of the week. Tonight's Word on the Street feature is about Advocate Malesela Teffo's withdrawal from the Senzo Meyiwa murder trial. So let's hear from people at Church Square and outside the Pretoria High Court, where the trial is being heard.
What are your thoughts on Advocate Malesela Teffo quitting the Senzo Meyiwa trial? Teffo can't just decide to quit the case out of nowhere.
I really believe it's a cover-up and somebody's being protected and the advocate is being threatened because he might have the truth about it.
So wale ya thoma tloela gore mo ya rena o ya fase re kwisa rwana o na le something se loreng a se right.
Why is he now want to quit? He must tell South Africa why, because this is an issue of South African thing, is a national issue. So he must clarify South Africa, why do you want to quit?
He has full right to do so. It could be various reasons, not only threats, but now, as a protocol or ethically, he has not done anything out of the line by quitting.
The advocate said about the president being part of a cabal, for me is nonsense. I don't think that the president orchestrated this matter.
We need to then go and try and understand where was the intimidation coming from, and is what he was saying in the proceedings, is there any truth to it?
These are serious accusations and claims, so if investigations are made, we can have ethical evidence to prove on which party is right and which party is wrong.
Advocate, therefore, I support him, I fully support him. Whatever he's saying because he knows what is going. And then he has been on the industry for a long time. Advocate, therefore, we are behind you.
All right, we bring the people with the answers to you. That's the whole concept of this program, where you also get a chance to ask those pertinent questions. That's what It's Topical is all about. I want to get you context to our discussion today. I have a few slides for you to better illustrate my point, and this talks to the code of conduct for all legal practitioners, candidate legal practitioners and juristic entities. Now, it talks to the integrity, which is very important, of the professional services. And it says, with regards to taking reasonable steps to avoid, a legal practitioner and a firm shall take reasonable steps to avoid and prevent any reasonable suspicion arising that the integrity is compromised in any respect. It goes on to say, performing acts in personal or professional roles or both, meaning whenever a legal practitioner performs any act in a personal capacity, which is ostensibly of a professional nature, they shall not permit any confusion to exist about whether they are acting in a personal or professional role or both. So that needs to be cleared. And the third one deals with withdrawal. A practitioner, a legal practitioner, shall, when a client gives conflicting instructions or attempts to retract earlier instructions, withdraw from the matter if continuing to act for the client would cause unavoidable embarrassment to the legal practitioner. It goes on to say, to this next slide, it talks about the issue of a legal practitioner who shall, in the composition of pleadings and of affidavits, rely upon the fact given to them by the instructing attorney or client in doing so, and this is very important, shall not gratuitously disparage, defame, or otherwise use invective, which basically means insulting, abusive, or highly critical language, and shall not recklessly make averments or allegations unsubstantiated by the information given to the legal practitioner. So basically that in a nutshell gives you context, right? What the code of conduct says, in part, legal education, morality, principles concerning the distinction between right and wrong or good and bad behavior. When this is balanced with the rules of the profession's legal conduct, how does it stack up? Let's bring in the better minds and let's bring in the legal mind in this respect. We are joined by Dr. Llewelyn, Curlewis, a senior lecturer at the University of Pretoria. Doctor, good to have you on the program. Firstly, to the question of the week, what we're asking the viewers, how does a legal practitioner need to act in open court now that we are seeing these proceedings in order to inspire trust?
Thank you, and good evening to everyone listening and attending to this tonight's interaction with one another. It's a pleasure to join you. Well, I think you made it very clear from the outset that the Legal Practice Act, Act 28 of 2014, is very specific regarding the ethical principles and rules of conduct regarding the code that is applicable to all legal practitioners. And this includes attorneys as well as advocates. Right. Chapter 4, specifically parts 4 and 6 thereof is applicable. And if one reads section 28 regarding the conduct of a legal practitioner, the implying underlying is one of diligence. Right. A legal practitioner must observe the law. The provision specifically in Code section 3.3.3 is very clear under the general heading that stipulates that a legal practitioner must refrain from doing anything in a manner prohibited by law or by the code.
What does that mean? In practical terms, Doc, what does that mean?
It means a person must act respectfully. He must act in the best interests of his clients, but always without insulting or demeaning behavior towards either your co-counsel, the court, the presiding officer, or for that matter, the state and the prosecutor involved. In other words, the highest integrity is required from a legal practitioner to be regarded as fit and proper to practice as such. That is in short.
Right. Is respect subjective? What I mean is that does it depend on who we're talking about here, or are there set rules in terms of how to act in court?
Yes, of course. We've got tried law. We've got case law over more than a century that stipulates exactly what is the requirements for a practitioner to perform and how he should conduct or she should conduct herself or himself in an open court. So this is not as if it's new. All legal practitioners, not only during their years of education at university, but also during law school and even during your pupillage. Right. This is one of the topical subjects that you will actually write an exam on to test your knowledge and ability to perform in accordance to the rules of conduct. So this is nothing new. It's strike law.
Right. We have our digital audience here tonight. You can see them on our video walls, a number of them. So my suggestion, if you have a question for any of our guests, please put your hands up. I think that will be the best in order to get to you first, because we have a number of people, limited time. With regards to, Doc, help us understand the system better. The need for cooperation between police, between the judiciary, defense lawyers, state, et cetera, it needs to happen. But who is responsible for that? Is it the prosecutor's duty, or does that duty lie with the presiding officer of the case in order to get this cooperation going?
Yeah, what usually happens is there's a distinction to be drawn here between the plead stage and the one that requires interaction after the accused has pleaded to a charge. Before you have pleaded to the charge, then the prosecutor or the state is what is known as dominus litis. It means that they are in charge of the proceedings and they are responsible to get the proceedings rolling in court, that things can start and start off expeditiously and continue. Once the accused have pleaded, then the presiding officer, whether it's a magistrate or a judge, will then take the responsibility upon him or herself to take over the course of the proceedings. And in actual fact, will manage the court case going forward up to conclusion of the matter in the trial court.
All right.
So that is the distinction that must be drawn.
011-714-5958 is the number to dial. Let's bring in our digital audience. Now, let's start off with Palesa. I know we have a number of students as well. Palesa, if you can unmute, with regards to the legal education that is currently being given to law students, and given the practicalities on the ground, be it, you know, you're in front of cameras, the proceedings are being beamed to a national, international audience, do you think the education is on par with what's currently happening, the state of play?
Hi, this is Malesela Teffo from the National Forum of Advocates. I think that it's sufficient, but also another thing would be that some things are just common sense, the manner in which you should conduct yourself. I mean, when speaking to a presiding officer, I personally wouldn't use foul language. So, yeah.
Yeah. Jolanda, Pretorius, common sense. How do you define common sense?
Well, for example, as I say, I wouldn't use foul language. I mean, even when we are going for our first court visits, when we are at varsity, we know when you walk into a courtroom as a legal practitioner, you're going to bow.
No, I hear you.
There's a manner in
I hear
which
you,
you are
Palesa.
going to address.
That question was for Jolanda Pretorius. Actually, I was just going to throw it to her. If you can unmute, jump in, Ms. Pretorius. What do you reckon?
What do I reckon common sense is? Well, we know that there is a very high level of respect in any court. I think all the citizens know that, whether you have a legal background or not. And it's just a reciprocal, sense of respect, which was actually mentioned in the court when Advocate Teffo withdrew from the court case. So I think good language, respect to the other person, respect as a human being. That's it.
Virti Ture, I hope I got your name right. Jump in on this conversation if you can unmute with regards to do's and don'ts for a legal practitioner. What do you say? Virti, are you there? All right, let's go to Tato. Tato, did you hear the question? If you can unmute. There you go, Tato.
Hello.
Hi, give us your take. In terms of a legal practitioner and the conduct of a legal practitioner in open court, what would inspire trust? Okay, it seems that Tato is not hearing us. Happy?
Oh, good evening.
Oh, go on, Tato, go on.
Good evening, everyone. Apologies for that. My name is Tato Mokhele from AMM Incorporated. As a legal practitioner, inspiring trust would really involve taking your client's confidence and the general public into your conduct as a practitioner, knowing that, displaying qualities that you know what you're doing and you know how to interact with the court. And, lay people never really know what court proceedings should be undertaken. So as a legal practitioner, to inspire trust to lay people, especially in open court, would involve displaying the highest quality of professional conduct towards, the general public, to your colleagues and to the presiding officer. So if I've gotten your question correctly, Blade, I think inspiring trust would actually involve displaying the highest quality of decorum, highest quality of conduct, not just to the court, but to also your colleagues, basically, within the legal fraternity.
Happy, let's get your take, if you can unmute Happy Godi. With regards to your definition of a professional legal practitioner, how do you describe
it? Thank you.
Oops, you muted again, Happy. Just unmute, Happy. There you go.
Can you hear me now?
Go ahead.
Hello? Can you hear me now?
Yes, go ahead.
All right. Yes. If perhaps you can just repeat the question for me.
Your definition of a professional legal practitioner.
A professional legal practitioner for me will be someone that firstly respects the decorum of the court, someone that respects the colleagues in court, someone that is prepared and understands the area of law that is practicing in and is able to represent and protect the interest of their client.
Let's go on to my left-hand side and speak to Manoko. Manoko, if you can unmute, what is the pushback or what are the consequences of somebody who is perceived not to be behaving in the right manner in court? What do you think?
Hi, everyone. My name is Manoko from Llewelyn Attorneys. What I can regard as pullback or the consequences actually is that when an attorney is not conducting themselves with the prescribed etiquette or is not conducting themselves as a fit and proper person as described by the Act, they can be suspended by the LPC or they can be actually struck off the role as an attorney.
Right.
Because it is, the conduct thing is, the manner in which a lawyer or an attorney conducts themselves is actually very important, and it is beyond common sense, or it is beyond just conducting yourself, having manners or general manners. It's beyond that, because as a legal practitioner, someone who has passed their boards or someone who is in the noble profession, you are expected, and even the LPC yourself, when you sign the contract with the LPC, you are expected to be able to conduct yourself in a certain manner. And when you do the exact opposite, you can get suspended or get struck off the roll.
All right, digital audience, stay with us. Dr. Curlewis, Llewelyn Curlewis is a senior lecturer at the University of Pretoria. We thank you very much indeed for your insight. We're going to take a quick break. When we come back, we're going to speak to Advocate Malesela Teffo as well as the Black Lawyers Association. What do they have to say with regards to the conversation of tonight? Next. Welcome back. You're watching It's Topical. It's a program that puts you, our viewers, at the center of the discussions. Please have your say regarding the burning issues of the week. Interact with us on social media platforms. Later on, we'll be taking your calls, 011-714-5958. All those extensions are there. Please do interact with us. Now, it's a murder trial with plenty of twists. And despite the criticism against Advocate Malesela Teffo's decision to withdraw from the case, Senzo Meyiwa's brother Sfiso is less concerned about the latest dramatic court events. This as Teffo's plea to have charges against his former clients now, dropped. He also felt the High Court in Pretoria did not have the jurisdiction to try the matter. This report by co-producer Mapheto Motlape.
A high-profile murder case with prolonged major upsets in court and making the headlines for all the wrong reasons.
There has been harassment that I should not be part of this case.
Defense advocate Malesela Teffo has shocked the court, withdrawing from the Senzo Meyiwa murder trial.
Advocate Malesela Teffo says he can no longer continue as he is being harassed by the state.
But before he withdrew, a struggle to find common ground.
The court has to listen what the parties have agreed upon.
No.
There is agreement.
The court has to direct these proceedings. I cannot hear from the two of you. I have to direct my proceedings the way I know proceedings should run. And you cannot tell me how I should proceed. I should direct those proceedings.
It's these visuals that set legal tongues wagging, and Advocate Teffo did not get over it with a jaw-dropping allegation.
On the 28th of April, when I was arrested before your court, Your Lordship, that was a plan. And the plan was hatched in the office of the president.
But the presidency did not hesitate to squash the claim.
The entire part is baseless, quite frankly mischievous, and reckless of an officer of the court. Whether he imagines this or whichever way he sees it, the president was not involved.
Advocate Teffo also blamed police and the National Prosecuting Authority. He claimed that the two institutions wanted him out of the murder case. But the state prosecutor did not budge.
I don't think it is proper. The people who don't have the opportunity to defend themselves. No, Mr. Valoy, I'm the one withdrawing. Can you sit?
Yeah, but you are withdrawing. You are part of the reason why you are withdrawing is because I am part of your harassment.
Yes.
Yes. And anything else?
No. Can I be allowed to say what I have to say?
No.
May I be excused?
Well excused. Advocate Teffo, you derobe once you are out of the court. You don't derobe here from.
Senzo Meyiwa's family have been watching the proceedings closely. His brother Sfiso welcomes Teffo's decision to quit.
Thina sesiyazi ngaloko nje evidence ephelele ukuthi khona umuntu abamvikelayo lapha ngaphakathi.
For legal experts, it's the delays that are more concerning, and Teffo is to blame.
Roping the president in, the NPA in, without even telling us in which respect they could be now harassing him. And it tells you that now it's a point where we could say that that's a sign of cowardice, because it now prolongs the whole proceedings. And that will also now be for him to be blamed.
And questions still remain. Who killed Senzo Meyiwa and what for? 8 years on, answers still remain out of reach. With 4 of the 5 accused now without a lawyer, Meyiwa's family is still without justice, perhaps just for now.
Say for how long?
The case has been postponed to August the 2nd to allow Teffo's former clients to find new counsel. For its Topical, Amariketa Mutlabe, SABC News, Johannesburg.
All right, Mr. Mutlabe, thank you very much indeed for your reporting. Now in studio, we have Advocate Malesela Teffo, as well as Theo Mapheto, who is the chairperson of the Black Lawyers Association here in Gauteng. We also have our digital audience. Just remember, we have the 2 guests here. If you want to ask any question, raise your hands. I'll immediately get to you. Let's keep it interactive. Gentlemen, thank you very much indeed for your time. Advocate, to you first, sir. You've heard a lot of criticism, not of late. It's been happening since this trial has taken place. No doubt you have those who are on your side. But how do you respond to those who say you are disrespectful and you don't hold a high standard in terms of the decorum within court?
Thank you, Blaine. Actually, you've asked the question and answered to yourself at the same time, insofar as the critics are concerned. You are built by the critics. They are like the brick. You take it and you build a brick wall or the beautiful house. So the whole of South Africa and internationally, I've got the support.
The whole of South Africa.
Yes.
There's a number of, look, digital audience, if you can jump in. I'll get to you in a short while.
Yes.
What makes you say that? Because you've heard the criticism, and it's obviously not all South Africans. But when somebody like Julius Malema, who said that he's very sympathetic to the Meyiwa case, but he thinks that you have made this case about yourself, your response?
Telling me about Julius Malema, it's a politician. See, I'm a lawyer. I don't have to say much about that because I'll also, firstly, I've seen that clip, and then there isn't Julius Malema responded the way he did. He was asked the question by the journalist, so he responded. As much as he himself being a populist, he responded. Because I wouldn't understand, in the press conference of EFF, what relevancy of the question of the Senzo Meyiwa's case at EFF's press conference? So I'm at court for the Senzo Meyiwa's case. So the bit that I can say Julius Malema should just keep his political work and his wood work. I'm a lawyer. I'll keep my legal work.
If somebody had to
I don't have to entertain him that much.
If somebody had to push back and say that, well, maybe you acting as a populist, like a populist, what would you say?
That's what I'm trying to say. I'm a lawyer. What I did, I followed the protocol. Remember, in this case, when I've addressed this before the court, that showed the respect that I had to say, if you are a legal practitioner in a court, and then you have to show the respect to the court of law, you cannot just be absent yourself. I'm formally and officially announced before the court that I'm withdrawing in this case. And the court accepted my withdrawal. There is a reason why I withdraw. I wouldn't just withdraw without the knowledge of the people that I'm representing. We are in concern. We've reached a consensus with the. I've appointed by Senzo Meyiwa as a watching brief on case number. You know that there are 2 cases in this matter. So before I quit on that day, Senzo knew, Mapheto knew, the younger sister of accused number 4, and the relatives of all the accused. So they knew. This is the decision that was taken. It was a bombshell and the breaking news to the media and other people who don't know. But now, I'm here to put the record straight. I haven't quit. I haven't lost to the Meyiwa case. I've got the attorney. My attorney's got the High Court appearance. So he's the one now who's taking the issue going forward. It's just that the thing maybe that is confusing the people is that on the day that I announced my withdrawal, my attorney was not in court. He was dealing with another matter elsewhere. Yes, but he knew about that. So there's no change much.
So all those who are concerned in this case were briefed before you withdrew?
Yes.
All right.
We had a meeting.
Mr. Mapheto, is Advocate Teffo being unfairly criticized? Or is there just cause to criticize his decorum in court?
Well, Blaine, thanks for inviting us. Let me first foreshadow my response to you by saying that the BLA is concerned that there continues to be hurt and pain that is borne by the family. The longer that this matter takes, the longer the pain persists. But to answer your question, we represent as a BLA more than 5,000 members, legal practitioners. On a daily basis, they appear in court. We are concerned that the spectacle that we have seen in the Senzo Meyiwa matter has sort of overshadowed the legal profession. We are not at a point where we want to pass judgment on the conduct that was exhibited by Advocate Teffo in court. But we are concerned that the case has been ongoing, and as you know, justice delayed is justice denied.
Right. Let's bring in a digital audience. First to Tabang. Let's take Tabang. Question, comment to our guest?
Good evening to everyone in studio and the viewers. Earlier you asked a question pertaining to education as to how legal practitioners should hold themselves, especially in public court. My comment is that we are seeing a situation where legal practitioner is jumping on a media bandwagon whereby it's a high-profile case, and the manner in which advocate carried himself in court seemed to be like it does not reflect the education in university as to how legal practitioners should carry themselves in public court. So also, are we seeing a situation whereby Advocate Teffo is being a populist or a celebrity in a case whereby it's affecting people for so long?
Yeah.
Because it seems like we're not, a case that has been going on for so long, we not even have finalized one witness. So, because justice must not only be done, but it must be seen to be done. Does he believe that by his withdrawal, which is going to make the case to delay even longer, does he believe that is going to help in this case?
Right, I get your point. Virtu, if you could ask your question.
My question, good evening. Thank you for having me and taking my question. I would just like to ask Advocate Teffo, there's sort of standard procedure where a legal practitioner withdraws himself. So I want to know why he withdrew himself instead of making an application to remove an application to recuse the presiding officer, and additionally,
I got
make an application to
your line,
Ms.
Ture, your line is so bad. Your line is so bad, but we get your point. Mapheto, to you, sir.
Thank you very much. Good evening to your guests. Two issues for me arise. One, the issue that Mr. Mapheto has raised on the delay of the case for Senzo Meyiwa. I want to juxtapose it with the reason why Advocate Teffo has withdrawn. One, Advocate Teffo has withdrawn on the basis that the court is harassing him, the state is harassing him, and the police, including the president, is harassing him. Now, as far as I know, as a legal practitioner, that might not necessarily be a good ground for withdrawal, because harassment from the court is just taking the punches and rolling with them as a legal practitioner.
Okay.
But two, and the last important one is to Advocate Teffo. My understanding is that he was acting for the 4 accused, and when he withdrew, he said that he will keep the watching brief over for the Meyiwa's family.
Yeah.
The question is, doesn't he see any conflict of interest in both cases, and especially in relation to the conduct of the rules in terms of the LPCA, where a practitioner cannot represent more than one client in a matter on the same day? Thank you very much.
Thank you very much. We'll come back to digital audience to get more questions. Let's get some answers, Advocate Teffo. Firstly, with regards to, are you jumping on the media bandwagon? Is that why you're acting like that in court?
Yeah, Blaine, there is this fallacy, and I don't know where is this coming from. In the first place, let me remind the South African who has got the amnesia. The reason the case is in court today, the peace-loving people that need the justice, not only for the Senzo Meyiwa family, not only for the accused that I represent. They say thanks to Advocate P, because I'm the one, the defense of accused 1 to 4. We are the one who make sure that this case come to court. When we came in, we have replaced the legal aid judicators. They were advocates from the legal aid that they since had the case since 2020. Let me remind you, the 5 accused were arrested on the 26th of October 2020. Since 2020, why the case never see the day in court? Every time then the case has to come, it has been postponement. So once we came on the 17th of March, we made sure that the case get into the court. And if you can also remember, we were the one that were pushing that, let the state put the charges on our client, then the case can run.
If you had to, you've been pushing for, as you say, a number of years. Why withdraw? That was the question from some of our digital audience. Why did you withdraw?
I haven't withdrawn, Blaine. I'm saying...
You withdraw in open court?
My attorney, my attorney has got a high court appearance, Mr. Tobani. So when I withdraw, like I said, he was not in court on that day. And it's something that is not a surprise to the family of the accused that I'm representing, to the Senzo Meyiwa of the Senzo.
All right, help me understand. So I just want to clarify. Let's take a step back. You did withdraw as defense counsel for accused 1 to 4, correct?
Yes, I said that. I announced that in court.
So when you say you didn't withdraw, what do you mean?
It's a strategy. You know, sometimes you have to confuse your enemies and give them a short-lived glory. So this is a strategy amongst us. As I said, that it's not a surprise. Senzo was talking here. He said, I'm not worried. But ask the question. I'm not worried.
Right. So it's a strategy. And you are delaying. You were saying that one of the biggest things for you was the delays in this case.
Yes.
By you withdrawing, that potentially contributes to a delay, isn't it?
No. Let me tell you. I said my attorney, Titi Tobani, Timothy Tsepo Tobani, is got a high court appearance. The case, if they postpone to the 2nd of August, there is nothing like we want to understand if these 4 people can be represented. They are still covered. They are still represented.
Right.
The case can go and finalize without me. So the only people that is delaying the case is accused number 5. The reason the case has been postponed today,
right,
the blame must go to accused number 5. They don't see the wrong of accused number 5.
It is a tactical withdrawal. Is that what you say?
In terms of our meeting and our consensus. Because what has been happening is that it's true, my clients and the family of my client, including Senzo Meyiwa, they've realized how much I was harassed. I've taken enough. Then we come to the
But that doesn't matter, isn't it? Because you're now saying that it was a tactical withdrawal. It's part of your strategy.
That's what right? I'm putting the record straight.
So
now.
all that, I mean, in terms of the alleged harassment, etc., doesn't really matter because you're saying it was a strategy.
It's the reason that of that harassment. So now we have to sit down, then when the situation is like this...
So how does the harassment and the strategy tie in together?
We did sit down, we said, okay, we sit down, and around this, we said, look, this is a situation. Remember, my client, I've even told the court, my client, for accused, 5 times, if I remember very well, giving the instruction that we should bring the application to recuse the judge. I said, no, guys, I've advised against that to recuse the judge. I said, no, this will delay the case. We need the case to be run and be finalized. According to me, the case could not even, was not supposed to go even more than 2 weeks, this case.
All right, Advocate Teffo, just stand by. I am told that I have Sinobile, let me just get it right. Sinobile Mapisa. Sorry, apologies. Sinobile Mapisa is joining us on the line, sister of accused number 4. Talk to us with regards to accused number 4. Now that Advocate Teffo says he's withdrawn, has your brother managed to find new legal representation?
Oh, hi, and hi to the audience and viewers at home. Yes, Advocate Teffo has never left us hanging or whatsoever. So, yes, we sorted with another advocate.
All right, and you were all privy to this decision in terms of the withdrawal before he withdrew in court?
Yes, unfortunately, I was the one who was not quite aware of the withdrawal, but all my brothers were aware as he consulted with them one by one.
Sinobile, thank you very much indeed for coming and explaining. Just stand by, I might have another question for you. I just want to bring in Mr. Mapheto. With regards to this, what you just heard in terms of a strategy of withdrawal, tactical withdrawals, is it insidious with regards to the justice system?
Well, firstly, if I were Advocate Teffo's lawyer, I would advise him not to take any more interviews because it tends to muddy the waters which are already muddied, as it were. The issue around the withdrawal fits into the delay that we are worried about. You would know that if a new advocate comes into the picture, he would have to familiarize himself with the record of the proceedings. So you'd have to have transcripts, which may very well take a long time as well. So we are concerned as the Black Lawyers Association, as I said initially, that this is taking rather too long.
Right. All right, let's go back to our digital audience and get Lawrence. Lawrence, your question, comment?
Good evening, Blaine. I think for the most part, I'm not quite certain as to whether the Black Lawyers Association would be of the view that we are not in a position to strictly come out and really, be quite straightforward as to how we view the conduct of Advocate Teffo in court, because this is something that has been observed on a number of occasions. So I'm quite interested on whether, there is any sense of being more straightforward, because I heard the member there saying that they wouldn't be so, readily, able to either point fingers or condemn or not. Is there really a gray line, or is this quite a clear and straightforward case? Thank you.
All right. Tsepo, you are from Mojapelo Attorneys. Your question, comment, if you can unmute.
Good evening. Thank you for having me. Tsepo Mojapelo, yes, from Mojapelo Attorneys. I would say, just as coming from the back now, that one, I agree with BLA's stance to say that let us not pass judgment on Advocate Teffo. Whatever our feelings are with regards to his conduct in open court is exactly that. It is a feeling until he has come before a panel, a judiciary, some sort of disciplinary hearing. Only then are they capable of saying that, yes, advocate, you have done X, Y, and Z, or you have misconducted yourself in X and Y manner, and therefore we find you guilty of this. Now, for me, the bigger picture here really is the delays that are being caused, obviously by withdrawal and all the other delays that have come before the court. Advocate Teffo now is saying that the families, or rather the accused persons, are actually still represented.
Yeah.
And my caution again to the general public is to say that there is a process that goes down in court, be it a withdrawal that happens, be it a postponement. There are always reasons for all of those things happening. And unfortunately now, because again, the case is now in full view of the public, it's very easy for the public to come up with to form some sort of conspiracy theory. But the main issue remains really that the conduct of attorneys or advocates in court is governed by a code of conduct. And once that code of conduct has, if anyone to answer to all of those, and until that happens, unfortunately, all we can do here is say that, yes, he was wrong, yes, he's not wrong. But personally, for me, I would say definitely using foul language is very incorrect in court. The decorum in court is such that we are expected to act in a certain manner towards our colleagues in a respectful manner.
We get your point.
But also on the other side as well.
We have to move. We get your point. I do apologize. We're just running out of time, but we get your point. Eric, to you, and then Llewelyn.
Thank you very much. Mine is very simple. I would like to ask Advocate Teffo, obviously with regards to the code it says all legal practitioners, they should represent their clients to the best of their ability. So now my question is that, does Advocate Teffo believe that he represented his clients to the best of his ability, considering the fact that the applications he was bringing, they could have been resolved during a pre-trial conference, Rule 37 of Uniform Courts Act, Uniform Court Rules.
Right.
And then another that, okay.
All right, thank you very much indeed. Eric, Llewelyn?
No, thank you very much, and to yourself in studio and the viewers. Mine is just a curiosity kind of a question. I heard the judge mentioning the issues of night school, day school, so I just wanted to get clarity if the advocate who has previously been admitted as an attorney, or did he go under privilege or not? Thank you.
All right, thank you very much indeed. I'm going to get to, let's get at least one or two questions answered there. Are you representing your client to the best of your ability, or former clients now?
I did. I've got the due diligence in terms of my the Legal Practice Council or the Legal Practice Act to do the best that I can do. And it has been that I've been saying, or I've been appealing before the court. I say, I'm here to make sure that I represent my client to the best of my ability as per paying the due diligence.
Yeah.
So as I said, like, I didn't just like surprise them. This has been, even themselves, like I said, my clients, they said no. You know, sometimes the way things were going at court, it was not, they were sometimes skeptical about the way the situation was going. Hence, they requested the recusal of the judge. And there were some times, if these people who's got the amnesia, I may remind them that there will be some times when I will request the judge, when I see that the things will go wayward, I will request the judge, say, Your Lordship, can we go to your chambers? Because there is something that may be happening here, and then we are in the public view here. So normal, and the judge will refuse. Where on earth have you ever seen when the lawyer said to the judge, Judge, may we please go to the chambers? There's something that very important, that you don't need the public to have a certain wrong perception about it. But the judge will refuse.
But,
and
you know, if you had, I mean, good enough reason, you should have put in an application for recusal, isn't it? Something that I want to talk to you about and what you said in court. And you said on the 20th, I'm quoting you, on the 28th of April, when I was arrested before your court, your lordship, that was a plan, and the plan was hatched in the office of the president, the #1 office of the #1 in the country. Have you spoken to the president? You know the president responded. Have you spoken to the president?
I have said that. I have said that. The president, I think a day or 2 days later, he responded by media release. So I've got on the bandwagon. I've responded as well. The subject is putting the record straight to the office, to the allegation, as far as the allegation against the presidency are concerned. I written the letter to the presidency, and then the letter has been acknowledged. And because the reason is that I know the president personally, you see. So hence, what I've addressed in there, it's not to the media, it's to the president straight.
You're not going to tell us what's there?
No, I'm waiting for the president to respond.
Okay, let's just, for context, let's play what the presidency said since your utterances in court. Please, could you roll that?
It will be irresponsible for us as the president's office to allow that level of misinformation to go unchallenged, because there will be people out there who will believe it, right? So we owe it to the public to correct misinformation. We owe it to the public to continuously enforce the president's standing and to enforce the image of his office and to elaborate and share understanding of what the presidency can or cannot do. But more importantly, this is an office that espouses the constitutional values that supports the safety, protection, and justice for all sort of principle and notion that is constitutionally enshrined. So when a high-profile matter as this one, a platform that's being watched by a whole lot of people is degraded in this manner and the name of the president is dragged into it, we can't leave it unchallenged, no matter how ridiculous it is. It is our responsibility to correct it.
All right, so the presidency, Advocate Teffo, went on to call it basically unsubstantiated, baseless, mischievous, calling for you not having an appreciation of the veracity of the facts, the conformity of the facts. Where are the facts in terms of what you just said at court?
As I said, then, that I've responded to the presidency, and it's about 84 paragraphs of my letter. It was received by the Office of the President on the 15th. And I've got the acknowledgement of the receipt. So I'm waiting for the response. I give the president until the 19th, yes.
Mr. Mapheto, with regards to all this that has come out in court and what's been happening outside of court, should this be happening, first of all, in terms of making these allegations in open court and how it plays out subsequently?
No, it shouldn't. But you see, let me deal with the question that related to the BLA around whether we are taking a clear stance on this issue. The stance is the following. To the extent that there is allegations of impropriety on the part of Advocate Teffo, we have a Legal Practice Act which regulates the conduct of legal practitioners. In terms of the Legal Practice Act, you have the Legal Practice Council, which is a forum which would be seized with any complaint should it arise relating to Advocate Teffo. So we are adamant that until such a time that Advocate Teffo is hauled before the Legal Practice Council, we cannot pass judgment. But we note that there are certain kinds of conduct which were displayed in the media, in court, which are unacceptable.
Right.
And to that extent, we say that as you know, the judge is also within his rights to refer the matter to the Legal Practice Council. But at this stage, we say the incidents that you see in court are a tiny minority of the incidents that you see in courts on a daily basis. We have legal practitioners who practice on a daily basis in court, but you don't see this kind of spectacle.
Right. I've got a minute left. Advocate Teffo, final word to you with regards to all your utterances, be it in court or otherwise. I know we had reporting about complaints to the Legal Practice Council prior to the Senzo Meyiwa case. Do you expect to be sued more now or be hauled before the Legal Practice Council?
Then let me say I'm just surprised. I'm not nobody from the Legal Practice Council came to me. I don't know of any complaint against me.
We had reporting, the Legal Practice Council has confirmed that there were a number of complaints predating Senzo Meyiwa trial investigating against you. The allegations relate to unprofessional conduct raised directly with the LPC. That's according to reports.
I don't know that. LPC never came to me. I know I'm accountable to LPC insofar as my conduct is concerned as a legal practitioner. I've been advocating for 12 years. And myself, in the second year, as a practicing advocate, I've got the Constitutional Court judgment myself now. People just know about Teffo now on this matter. And this matter is, every matter in terms of the law, we say, each and every case has got its own merit. It has to be judged according to its merit. So I'm so surprised to hear that I'm getting the blame from all walks of life. For what? I don't know. And then I said, until that time, as you say, Mr. Mapheto said, that the LPC should have the guts. If they don't have the guts to come to me, then I'm not going to take myself to the LPC like the cattle goes to the abattoir. You see? So I'm still waiting for that. So I just hear from the rumors. So LPC is got the right to call me if there is anything. And I don't see, I'll be waiting for them. And this thing is unfair. It's very much unfair to me when it seems as if there are certain people outside trying to influence LPC. You see? So,
all right, we'll see how that plays out. We'll watch very closely with regards to the response from the presidency as well, following your letter. Advocate Teffo, thank you very much indeed for your time. Sir, Mr. Mapheto, always a pleasure. Digital audience, great to have you. Here's my take. Dwight D. Eisenhower once said that peace and justice are two sides of the same coin. It's two things that the Meyiwa family do not have yet. No peace without knowing who killed Senzo. No justice almost a decade later. Justice must not only be done, but must also be seen to be done. You heard one of the digital audience say that. And you get to see it playing out in real time right here on this channel. But alas, more delays in the case. For me, the question is, how do you ensure procedural fairness, but at the same time, acting with full tilt as fast as you can? The answer to that question needs to be constantly in the minds of all who serve within the justice system. Processes and rights given, I understand that, but they must ensure that the unpleasant effects of the crime itself must not be made worse by what happens later, especially for the victims and the families of the victims. And that's my take. Remember, tomorrow is Nelson Mandela International Day, so remember to spend your 67 minutes of your time by doing good. And the world needs good, you would agree. The news continues. Stand by for the Globe. Until next week, take care. Bye-bye.